we had a nice conversation in the last one. And this one is something, of course, we have to hear Julie's view also, which is important. And the topic, of course, is what mediation in the court system, Boon or Bane.
That's right.
And we maybe look. I mean, you haven't heard me because whenever I had that symposium last year, 97 speakers. So I think there were some two speakers in one. So maybe about 93 sessions. 93
Wow.
sessions I spoke about this aspect. I said this is something which, according to me, has affected the way mediation should have developed, and I kept on talking about it. And of course, people in some way or the other had thought about it, but no one questions it, because finally what happens is mediators are part of the court system. They will not criticize that. Everyone wants to be close to the judiciary. No one wants to criticize it. And me, because I'm disconnected from it, I can, of course, totally, I mean, say whatever I want to. So
Right.
that's, I'm not I'm criticizing for the sake of criticizing. I really want an open
Right.
discussion on it. I mean, but because it's a different session, so please, you'll have to also just a little introduction about yourself. So Julie, you want to just
Sure.
tell us a little bit about yourself?
Yeah, let me just introduce myself. And first of all, thank you, Vikram, for inviting this topic. We started a brief discussion about this last week, and this is actually very near and dear to my heart, because I was a law professor. I was a mediator and did both of those things at the same time. I teach people trial practice skills. I have significant research and practical interest in issues related to domestic violence and abuse. I have been a mediator for 15 years before I was appointed to be a judge. And I think, as a result of having been a mediator and a law professor and a teacher and doing all the things that I did before I became a judge, I had a different perspective from the bench than my colleagues did. I've since retired from the court about 8 months ago, and am once again doing mediation along with my work with the Concilium Institute that we talked about in the previous session. So I won't go into great detail on that. But I think I've got a unique perspective on it. And I think it's interesting, Vikram, that you say that you're outside of the court system, so you can criticize the court system and the way that the court uses mediators. I think I am in a very unique position to be able to do that as well, because I have the perspective of having been on the bench. I have the perspective of having been a mediator before I joined the court, and since I joined the court. And I will say that in the 25 years or so from the time I first became a mediator until now, I've seen some significant differences in how cases are mediated, at least in my jurisdiction, and what the expectations of the court are. So I'm very excited to have this conversation with you.
No, really. Yeah.
Um,
Yeah. And Heidi, you just, because I know you want to leave a little earlier, but please, you have to also introduce yourself. It's a different
Sure.
session.
Yeah. No, I'm Heidi Webb, and happy to have this conversation about mediation. I actually did my mediation training when I was a law student. So back when God was a boy, as they say, it was a long time ago. But I trained with a man named Patrick Fear. I don't know if any of you are familiar with Patrick's work. He was in New Zealand, and he developed a model that he must have developed it in the 70s. So it was really early on, and it was a two-person model. And I was working with, so you were always co-mediating, and we were working in a situation where generally our clients were people who had immigrated to the US, and there was a cultural clash between the children and the parents. So they were always peering sort of a younger, law student with an older person in the community so that the alliances were sort of parent and child driven to some degree. I mean, there was overlap, obviously, we weren't the ages of the children, but they were pretty much teenagers and cultural clash issues. And it was a fascinating way to learn about mediation and to have the support of someone, from my perspective, who was a bit older and wiser than I was, and to be able to caucus with that person and understand how these dynamics could sort of be distilled and sort of like broken apart during the process. So that was sort of my entree to mediation.
Perfect. So what I mean, look, I don't know, Julie, you want to? I mean, I should start it off because the thing is that I have discussed this a lot. So
Yeah,
I'll tell you. Okay.
I want
You
to
ask
start
questions.
with you. Yeah, no, I want to start with
Okay.
give me your précis, give me your
Okay.
summary, give me your
Yeah,
abstract.
I'll give you the broad part of it. But the basic thing it starts with is that yes, we talk about promotion of mediation. That's one part of it. What for me, the mediator is an important person. Like I've been saying, this I think this joke is not going to carry on too long, but I keep saying, oh, I just recently got to know mediators are also required in mediation. So I'm just saying that somewhere down the line, they got lost out. And for me, that
Yeah.
is the first thing. If you don't have mediators, where is mediation
Yeah.
going to happen? So from that perspective, also, we're going to look at it from that perspective, definitely, that where does the mediator fit in? What are the issues for the mediator? So that part of it, definitely. And in general, connection of mediation with courts, is that a good concept? How do people look at it? Then what the mediator gets or what parties pay for mediation, whether they pay at all or not, whether that devalues mediation in their minds.
Right.
Then the other aspect of, because the judiciary wants the backlog to go away, they find this as a route to maybe reduce that. But is that really, should that be the reason? The other thing is that the fact that mediation is a totally different process and the courts have a different, are there for a totally different process. Should that at all be put together at all? I mean, the two different things. Then that whole colonial concept that I talk about, that colonial mindset that disputes have to be resolved in courts and lawyers have to be part of it. That aspect of it, again, by connecting mediation to the courts, are you bringing that part again into people's mind? Can we not at this stage remove that from their mind, because that definitely affects the way they look at dispute resolution. So are we going to look at that afresh? So these are the kind of things that I mean, these are some of the points that I've told you. So these are each of those issues, like I'm telling you, just want to listen to you on this because of your experience on, and all these things that you said will bring in a good perspective. So I'll just listen. I mean, I've been bringing each.
No, jump in. I want, please, Sherry and Heidi and Vikram, I want you all to jump in and question, challenge, add to the discussion. I'm going to take a step back though to when I first started as an attorney, and was first representing clients in family law cases in Michigan, Massachusetts, different jurisdictions, Illinois, different jurisdictions, but there was a common thread with all of those. And that is, I would go to court with my client and the judge would say, well, come back to chambers, everybody. And the judge would work very hard to browbeat us. I mean, literally browbeat us into a settlement. And became the settlement conference overseer. I won't say it's mediation because it wasn't mediation. It was browbeating. And it was particularly challenging for me because I was representing primarily abuse victims, so domestic violence victims who were put in this situation of the judge being angry with them and with me, and carrying that forward into the courtroom if we didn't agree. And there were issues that I couldn't reveal to the court and didn't want to reveal to the court because of safety and client concerns about safety. So that model, I think, still exists in some courtrooms and some courthouses, particularly in more remote areas where it's, one judge who decides all of the issues in say a rural jurisdiction is looking for that kind of resolution. So I think mediation is a piece that may have, from the court's perspective, grown out of that, let's browbeat people into a settlement and get it done, because that is what is going to help the court. So I think you're absolutely right, Vikram, when you say, that this has become an arm of the court with the goal of, let's get people to settle. That's the court's interest, is in getting people to settle, but that's not necessarily consistent with what people need to get from the mediation process. So from the court's perspective, there's, going back to your title of Boon versus Bane of mediation, it's a boon for the court, and frankly for folks who are sent to mediation by a court, because it does give them the opportunity to resolve issues that they disagree about. If they are lucky enough to get someone like Sherry or Heidi or a very experienced, or Vikram, a very experienced mediator who understands the process of mediation, then they will benefit from that. But because the court's goal is, let's get it settled, the mediator's goal often is, I've got to get this settled. And mediators feel often that they failed somehow if they don't get the parties to reach a full agreement. And so I think that mindset needs to shift. Heidi, you were going to say something.
Yeah, no, I was just going to say, I don't really see court mediators as mediators. I see them as like resolvers. It's just sort of like the place you're sent to come back with something the court can make an order of, and you've got a half an hour to do it, and there's a long line out the door. And, it's just so antithetical to the process of mediation. And I think it's really a misnomer. It became sort of like a sign on the door that said mediation, and judges would say, go down the hall to mediation and come back, within an hour with something we can sign. Right. That's just like not mediation. It's just people are calling it mediation.
Right.
Because we had something like something of this kind of discussion with Sherry just before you people came in for the last session, about whether we should accept that as mediation. First of all, because there might be a culture of doing that, but and the word mediation has been put on it, but should we accept it or not? And that's
no.
But I didn't introduce Sherry because the video was off. Sherry, you want to please just quickly tell us about yourself? It's another session, so please.
Hi, I'm Sherry Bruckner. I'm a mediator and licensed attorney in Minnesota. I practiced for 20 years. I too worked with a lot of family law cases for probably 17 of the years. I worked under a VAWA grant, so a long time working with victims of domestic violence. And yes, this process, I think we forget that it's a process. And when we're in litigation, we see it as this thing that can go on for 2 years, and forget that, well, when we go into a mediation, it's still a process, and people still need to process all of it.
Yeah.
Perfect.
Yep.
Yeah.
So,
absolutely.
So Julie, what are we going to do? Are we going to take it step by step? Let's go first to the colonial mindset. The colonizer created institutions, and the colonizer wanted people to go to their institutions. And you cannot resolve things yourself. Come to us. We will do it for you, kind of thing. So has that carried on, that mindset, that conditioning that has happened? What do we need to change that if we want to? If we have to change it, I feel we do have to. But of course, your view, I will take your view also on this. But first, we'll start with that, because I feel that's where the root is, and then we'll go from there. So, yeah.
Well, I don't know that we can change it. I'd love to hear your thoughts about how we can change it, because I know, especially in the US, it is the place where people go to resolve their disputes. And even when they come to mediation, let's say in a family law case or a civil case, before they go to court, they are doing that with an eye to court and going to court. I've done a fair number, since I've been retired, of civil mediation cases, civil disputes, contract disputes, that kind of thing. And every one of those came in as a precursor to going to court, because there was a contract provision that required mediation before they could go to court. So mediation has become the I won't say
The
gatekeeper,
carrot or the
but
stick. Yeah.
yeah, mediation has become a gate through which people feel they need to go, either after they've filed their case and are ordered by the judge to go to mediation, or before, depending on, any prior court
Contract.
orders or contracts or things like that. So I think that mediation, at least in the US, is tied together with court in many people's minds. The real problem that I see with court mediation, and we have a different model, I think, than what Heidi was describing, and that is that the mediators, the court-ordered mediators, are folks that people go to here, are private contractors that do charge. They're not down the hall. They're not physically
Yep.
located
We have
in the
some and
court.
some.
Yeah. But ordering mediation sets it out as an obligation and a gate to jump through rather than an opportunity. And many of the folks that hold themselves out, at least here locally, as mediators are attorneys who have never done mediation training. They basically do what I call settlement conferences. It's like, what's your offer? What's your offer? What's your offer? What's your offer? With the goal of getting to a resolution. So the court expects resolution. The settlement conference attorney, I won't call them a mediator, expects resolution, and it becomes more of that, I'm going to go between rooms and carry offers. I'm just going to be a messenger. And that's what many people envision as mediation. And I think people get challenged. When I came off the bench, I had a lot of folks who signed up for me with mediation because they're like, oh, Judge Field, she can tell us what's what and tell us what to expect. And I make it really clear. I think I heard the tail end of Sherry and Vikram talking before our previous session about how people expect that evaluative piece, that I will tell them what the judge is likely to do, and I tell them that I'm not going to do that unless they specifically agree that after we've gone through the mediation process, that's what they want to hear. But I'm not coming in with that first thing. And I'm not going to tell them unless there's clear agreement that that is what I'm doing. I do the mediation process in terms of the discussion and the questions and the facilitation. And I think many of the attorneys here are uncomfortable with that because, as I said, it evolved in the 25 years since I started doing mediation and then was on the bench and then came back to doing mediation, that there's a high expectation. And I think some of that is Zoom related. Some of that is related to just where we're at as a society, but people refuse to be in the same room, even when there's not issues of safety concerns or things like that. They just refuse. And when I start people in the same room, the attorneys get very uncomfortable with that. And I'll ask a question like, Ms. Smith, tell me about your kids. Well, she's not going to answer that. It's like, I'm sorry, what? She's not going to tell. You don't want her to tell me about her children?
Right. There are a couple of things I know I have to jump off and I'm really sorry, but I just wanted to raise a couple of things. I mean, one is, at least in Massachusetts where I practice, the courts send out a notification as soon as something's filed, telling lawyers that they're required to tell clients about alternative dispute resolution processes. Mm-hmm. What that usually involves is a lawyer sort of saying in a very offhanded way or an offhanded letter, this is something that, is available to you, but, in your instance, it's probably not going to be that useful. So like, let's get on the litigation path. So it's sort of a throwaway that's required, but not. The other piece that I think is important is what you're describing is lawyers' expectations of mediation having an evaluative piece. here is really called conciliation. And that's differentiated, but what you find is a lot of lawyers using it as opposed to mediation because it's evaluative. So you'll get people saying, you know, we can get a retired judge to do a conciliation. That's going to be a lot better for you than mediation because we think we'll get an opinion that's going to carry some weight when we go to court. So it's sort of, you know, it's all steps on a staircase, right? But the top landing still court. So I think that that's another piece that complicates things here.
But you can't leave, Heidi, because you can't leave right now because what you picked up, I have to also clarify this aspect. Thing is that in your statutes, in the courts, there is a definition of mediation and conciliation. So you have that, so there is a differentiation. Otherwise, outside that, today, I mean, look, our statute, of course, doesn't have a definition. So where do we go to? We go to the Singapore Convention because we've signed the convention. We haven't ratified it, but okay, in principle, we've taken that definition. So I go there. And the definition is very nice and broad, a process by whatever name you call it, however the process is done, as long as the third person, that is a mediator, doesn't have the authority to impose a solution. As simple. So mediation, conciliation, UNCITRAL and its model law has clarified. They're all the same. We were using the word conciliation earlier, but mediation seems to be what is popular. So now we are using the word mediation. So because why it's important, why I'm asking, telling you to stay here is because this potato thing has been happening in a lot of places, specifically in India, because the law that we picked up was from the UNCITRAL model law, which was called conciliation in 1996. We have the best law on mediation, and the entire country, everyone is saying we don't have a law on mediation. There's a bill lying in Parliament which is called the Mediation Bill. So we are going to get a law on mediation. Please look at the conciliation. Does it fit into your definition in the Singapore Convention? Yes, it does. Why is it not a law on mediation? So because, I mean, there's a nice clarification in the model law, UNCITRAL model law. So nicely, they've actually put it down. It can be called mediation, it can be called conciliation, or any other name. So I mean, it might not be, it's moving away from the topic maybe, but this is again something that I keep talking about all the time because the user is getting confused. The user wants a process that, I mean, what is that process that you go for here? I'm confusing them by saying, okay, this word or that word, no, this is not how it's done, the model concept of it. And at the end of the day, user has no connection with all these things. And it's that one dispute that they have. And we've given them the whole theory around the whole concept. So that's a big issue. So we're having a discussion on that later also, on the models part of it, on the of those.
Fascinating.
So now if you want to leave, now you're okay. Okay,
well, I'll come back for another discussion, but I do have to leave. But thank you all so much. This has been a wonderful way to start the morning. And I hope we have many more conversations.
Yes, very nice meeting you, Heidi.
All right. Take good care, Sherry. We're happy to talk offline. Okay. Bye-bye.
So Julie, also what I'll do is I'll give you a little more of a background of where I am, of course, coming from.
Please.
The US situation is that 100 million matters go into courts. And we keep saying that, okay, so many % of them get resolved by ADR. How many of them are mediation? I haven't been able to find those statistics, so I won't get into it. And why I get into the US situation is only because there is this box of mediation which has gone out to the world. And what the issues there, which I have been able to discuss and notice and I get into is that if 100 million go into with a population of 300 million, and the numbers in a particular report in India which came out were similar, that many disputes exist, but in the courts only 18 million go. Can you imagine a population of 1.3 billion people?
Wow.
Only 18 million go into courts. So in that kind of a situation, if we follow the US route or route, let me say route, we say route. So if we follow the US route, then in that case, if we get those 500, 400 million matters going into courts, we can't handle 18 million. We have 50 million cases pending in courts. With only 18 million going in, 50 million are pending. 18 go in, 18 go out. That backlog doesn't come down. So if we go this route, can you imagine what our court system is going to collapse? So you have to look at it from a totally different perspective. Then I keep saying, let's dig a little deeper into the US situation. It's important because the formal concept of mediation, 40, 45 years in the US, what has it produced? So let's look at that. And has the court system been responsible for certain things? Because or we keep listening to people talking about how it started in the court system. So India started its first court system thing in 2005, picking up from, I think some people from the US came in for doing some training there. So that model went into other places. But did anyone dig a little deeper here? So finally, what is happening? Let me tell you what this final thing, what it looks like. You will take us through the process. Final thing looks like lawyers control mediation. Lawyers decide who's going to be the mediator.
Yep.
Lawyers control the process. They get their fees, of course. That's one part of it. And the mediator gets lost out, thinking that the lawyers will recognize me and then I will get private work. That doesn't come in. The whole lot gets disillusioned, moves out. Another lot comes in, goes through the same process. This is not my words. This is Jeff Kitchavin. He's a mediator who only practices as a mediator. In the last symposium, we had a discussion. He's also spoken at the Beverly Hills Bar Association talking about this. The other thing he talks about is free and pro bono. You have to differentiate the two because it's being doled out free. Why is it being doled out free? It's not pro bono. We understand. Yes, there is a requirement. People can't afford it, but people who can, he says, he was talking about the Beverly Hills Bar Association. Look at the people around you.
Right.
They need free mediation. So these are the kind of things which are coming out, because I'm saying that a lot of countries can't afford to go through this route, because if they realize this after the next 10 years, things would have collapsed. So whether if you're not going in the right direction, what are the issues, and of course with your experience. So I'm just trying to take it in from that point of view. So let's look at it from the long-term global perspective.
Yeah. And I want to hear from Sherry as well, from her perspective as a mediator and in Minnesota, and where you get your cases from and what relationship you have with the court. But in terms of that global perspective, yes, the system would collapse. I mean, that's true. We look at that a lot in the US in regard to the criminal, so-called criminal justice system. I say criminal so-called justice system is really the way I should describe it. Because there, 98% of all criminal cases resolve with a plea, entry of a plea. And if they didn't, the system would collapse. If everyone who is entitled to a jury trial in the US system in a criminal context asked for one, it would collapse. And we wouldn't have time in the court system to do any of the civil disputes, or that many of which resolve in mediation, or the family law cases. There would need to be some other solution to dealing with those. I think the numbers are similar in terms of civil cases and family law cases. 95 to 98% of all cases resolve before going to be decided by a judge. Some of those without mediation, just through negotiation, or through a settlement conference or conciliation process, or through mediation. So I don't know what that breakdown is in terms of mediation versus, the lawyers negotiating a settlement. But I think that mediation as the catch-all was created for a couple of reasons. One is, I think people were coming out of law school in particular, and maybe some other disciplines as well, looking at mediation and saying, wow, this is great. This is a fantastic way to resolve disputes. It coincides with my philosophy. I went to law school because I wanted to help people. This feels more like a way of helping people than going to being a hard driving litigator. And so I think a lot of people came out of law school and said, I want to do this. The courts adopted it as a way of resolving cases because it's helpful to them. And so many places do have requirements of mediation. Free mediation is part of it. As you were saying, the Beverly Hills Bar, they don't need free mediation, but they're getting it because the court sees the value in it to the court. But I think you're right. It devalues it to the parties, particularly those that can afford it. So I think it has become this sort of catch-all of, let's get cases resolved. We realize as judges, it's not ethical for us to take people back in our chambers and browbeat them. So let's figure out a different method that we can use to get people to settle issues, because otherwise, you're right, the system would collapse. And for those people that are court ordered to mediation and get someone like Sherry or someone like Heidi or someone like me or someone like Vikram, they're going to gain from the discussion and the mediation process as long as they really are able to engage in it and not be shut down by their lawyers, like I've seen more frequently recently than I did 25 years ago when I started doing mediation. And I think part of that is that people have a different expectation of mediation, having had 25 years of experience with it, right? And when I started, it was relatively new. I mean, the court orders that I got for mediation were something that hadn't happened before I started doing mediation in our community. And I did go to the court and say, I'm a mediator. I think you need to start ordering people to mediation. Got a great business as a result of it. But I don't know, Vikram, maybe I'm part of the problem then too.
Look, I tell you, I have two parts of it I will take out from here. One is on the colonization part of it. We're having a separate discussion on that, because obviously we still have to have a discussion on what is going to be the role of courts in general. Like I said, the colonizers' courts was a different concept. Are we still wanting to continue that, or are we looking at the court system differently? What all should actually go to the court? What all should the state actually put up in terms of a court? For what reasons? I mean, you do that basic commercial thing. You don't pay me this or that. Should the state be creating infrastructure for it and have judges? I mean, I'm just, these are just points I'm just throwing out. I'm not saying that. Look, I'm not concluding.
Absolutely.
So one, on the entire concept of that colonization and the effects of it, and of course colonization and decolonization. So we'll have a different discussion on that. I won't bring it here. The other thing on mandatory mediation, we're having a separate discussion. Whether it's go, I mean, I've called it mandatory mediation, to push or not to push. That is a question. I haven't said that is a question, just a question mark. But so we'll take those two out. I'm not, because I wouldn't want to put everything into this discussion. The important one here is one, that the fact that the system, the court system, has been put for a certain reason under the constitutional framework. So can you tell parties to actually pay for mediation? Because otherwise they can challenge the whole concept that
absolutely.
Look,
I think absolutely you can ask people to,
no,
you can require people to mediation.
No, this was challenged. Actually, this was challenged in some country. I think Romania challenged, they challenged, they had to scrap the entire mediation. They had some, I think they were able to create some 10,000 mediators. As I mean, I don't quote me on it, but I think about that many, and they scrapped it, everyone out of work. Because the challenge was this, that we've got the court system under the constitution framework. We've come to you for a certain kind of resolution. How can you send us for something else? And if you're going to tell us to pay for it, that it definitely doesn't happen. So either the state funds it. Is the state going to start funding people's disputes now? There's so many other things for country. And look, you have to go beyond the US, definitely. And in the US also, there are so many issues. I mean, if you have a homeless person there, but here we want to resolve, want to fund your dispute, that doesn't sound all right. So those are also discussions we need to have. And of course, what the issues that came up, like you said, I mean, we were discussing, is it really mediation that comes out of it? Because the way it is done, someone in the court system here, some lawyer who was practicing in a court system said that if you give peanuts, you'll get monkeys. I mean, is that the kind of thing we want for mediation? Then what do parties take back? Well, again, go to the US experience. Today, after all these years, if you are still going to go to the courts first and you're going to go to a lawyer first when you have a dispute, I think we've missed out on something. There is some issue there. I think because I feel that if mediation is a dispute resolution process which people appreciate, and word of mouth is what should have happened in the 40-45 years, if that is not the first port of call, we need to go dig deeper into that. Because if that's the way it's going to be, then like I said, it cannot happen in every country. Even in the US, it should not happen. You can't go into courts everywhere. People don't have access. I mean, can you imagine say our Supreme Court is 2,500 kilometers away from some parts of India. I mean,
Mhm.
that's a Supreme. We have one Supreme Court in Delhi, but otherwise, high courts are thousands of kilometers from some
Mhm.
parts of some states. We have states. We also
Right.
divided into
Right.
states. So, I mean, in
Right.
those kind of situations, when we can actually promote mediation as a standalone thing, and the kind of law like we have
Mhm.
here, which I call say the best law in mediation, which people say we don't have a law in mediation. At the end of the day, a person gets a court decree. That settlement agreement is as good a court degree, and you don't have to do
Mhm.
anything. There's no registration required, nothing. So without the influence, the effect or the judiciary coming in or the government coming in, no one has to come in. You do it on your own, your process, you get your court
Right.
decree, which now, of course, like I said, a mediation bill has been put into parliament because obviously the colonizer mindset has come in. Why are we not
Mhm.
part of it? So that part is coming in. But I'm just saying that these are not, I mean, options for a lot of countries to go through the court
Mhm.
system and to create this kind of a structure where you come in and you go to a process which might not be mediation, but it will be called
Mhm.
mediation. Is it a settlement conference, or is it really mediation? You what bad? I
Mhm.
mean, the name that mediation gets out of it, because I hear, I mean, I'm sure there also parties say we just went there, the mediator told us this is how you have to do it, and you can understand what background people come into. Villages, people come from
Right.
villages. Now you've gone into a high court and you have a robe, and like
Mhm.
luckily we don't wear wigs, but in Nigeria they're still wearing
Mhm.
wigs, and you walk into that kind of atmosphere. That villager is, I mean, he doesn't really know what this whole concept of mediation is. We are talking about it in the mediation world. They don't know about
Right.
it. They just know that the court said go to this person, and when they went to that person, the person said this is what you have to do. And I have an
Right.
interview, some mediator in India says the mediator will decide. He's saying that 4 times in the
Mhm.
interview. So can you
Right.
imagine? This is what I'm saying. These are the effects of that. What are we passing
Yep.
on to this? So I mean, look, I don't. I mean, don't want to talk so much. I
Yeah.
should not.
I'm
I'm
no, I'm
leaving it
not
here.
I'm not disagreeing with you. Sherry, what's your perspective as a mediator? I mean, I've been in different positions and I'm just very curious your own perspective on that.
Well, it's interesting. I want to go back to one of the points that Vikram brought up, which is the going to the courts for resolving our problems. And
Mhm.
I feel like as a society, we've gotten away from having conversations, and
Yep.
court is not the last resort, it's the first resort. And now I
Mhm.
think we're pulling back a little bit from that. And I'm actually having people come into my office for divorce mediation before they file anything with the court. They come in
Mhm.
and have the conversation. And I think that's partly because of my reputation as the person that sits down and has the conversations. So does
Mhm.
that mean the attorneys want to choose me? Sometimes not, because I'm not the decision maker, settlement conference
Mhm.
shuttler. And so that's really fascinating about, those different approaches. Here
Mhm.
in Minnesota, we have it mediators listed as evaluative mediators or facilitative mediators or both. And so people kind of know what they're getting. And I'm
Okay.
not in the evaluation list, I'm in the
Mhm.
facilitative list. So that's different.
Mhm.
But going back to the conversation part about helping people have those conversations, we are, I feel, coming back to that and encouraging that. And there's a group
Mhm.
of folks in Minnesota actually looking at seeing if divorces, just the actual dissolution of marriage, should not be a court process, if it should just be kind of an unlicensing. Do
Right.
we let people unmarry themselves and just send in the form to say administratively
Mhm.
we want to be unmarried, and
Right.
without going through any sort of process?
Right. Yeah, and I think that runs into I think that would be fantastic if we could do that. But I think what that runs into is the state, at least in the U.S., and the states have an interest in property division, in the welfare of children, right? In making sure that taxes are adjusted accordingly. So, I mean, there are lots of state interests that come into a relationship when someone signs that license at the beginning, and the state carries through that interest, which people don't really realize. They're just planning their big wedding and not thinking about I'm bringing the state into my relationship, but that's exactly what they're doing. And so then the state maintains that interest in it, and unless and until we shift that mindset, and though some of those laws, I think that is going to continue to be a challenge.
Because actually, finally, Julie, the thing is that the colonizer had a way of actually administrating a colony with very few people. So they had to rely on laws and their
Mhm.
institutions. That part of it, the people who took over, they used those laws because those laws were made so perfectly to administer with very few people, with total
Yeah.
control. All the
Right.
discretion and everything
point.
put in there, because obviously you don't want your person to get affected. So you need the discretion. The judges have to have all kinds of discretion. But there, it's the
Yep.
colonizer's institution. We haven't changed that. I mean, I keep telling people that our Indian Penal Code, I don't know if you want to give me a guess on what that year is. When do you think we got that Indian Penal Code that we have?
The Indian Penal Court?
Yeah, just a guess. What year?
Ooh.
We got independence in 1947. Let me just tell you that.
Okay. I would say, well, the Indian Penal Court, I would think predates that independence.
Majorly
Does it?
predates that. Majorly.
Yeah. I was going to say maybe
It's
the
1860.
1700s.
18, okay,
Okay, I was going to
1860.
say the 1700s.
So the people who took over use the colonizers' laws. So our civil procedure code is 1908.
Yeah.
We try to regulate, I mean, legislate and everything, but don't pick up on certain things because the colonizers' structure was so good for people. So judiciary doesn't want to change that. Judiciary, I'm like our Chief Justice went out and put up a committee to look at the bill, the mediation bill. And I kept saying, I keep criticizing. I said, what does the Chief Justice of India have to do with the mediation bill? They should be looking at these laws. These laws are still lying there. So there is that whole mindset that they don't want to change things. And I'm not saying in the Indian perspective, I'm saying globally, the judiciary wants what it wants. It wants to have that control. And this is the colonizer's mindset. Like you right now said that, look, we have these laws. And I'm saying, question them. Question those laws. I mean, you said these are laws, so they have to be followed. Today, we're at a platform where we can say that what is required, what is not required. Like what Sherry just said, that in this kind of a situation, why is the state to be involved? I mean, we have to question those things. Those are not questioned. Yep. How do you get to any solution if things are not questioned? So I think that part of it is I don't know. I'm saying let's keep it to the colonization discussion, because that part of it, otherwise we'll go out of the court part of it, because the court part of it is also a very major discussion, a major discussion as to how we want to structure it. And with your experience and with so many years of experience, I think, taking off the hat, that's why I asked you, does the judge's hat stay? If it doesn't stay, taking all the hats out and only the experience left.
Yeah.
Out of that, how would you want to structure mediation in the US?
Fantastic question. I would structure mediation as not necessarily completely independent from the court system, because I do think that particularly in the US, as we were discussing, it would need to be a major cultural shift for people to come to mediation first rather than to, I'm taking you to court, going to court immediately. That's always the threat. And I think that people recognize, because that is the place where people see disputes be resolved, that they understand court as the stopping point and what a court would do as the stopping point. So I think you can't separate those things out completely. But what I would like to see is more understanding, education, and creation of mediation processes, mediation as a pillar of dispute resolution that is independent of the court, and that promotes the facilitation, like Sherry was talking about, and the true mediation process. I mean, if people want to go to court, need to go to court, and they can't resolve things through mediation or other alternate dispute resolution processes, then I think that they do, then maybe a settlement conference type solution is appropriate. But I think people need to have that cultural shift. If I were the queen of the universe in and could change the U.S. system, I would make mediation one of the standard pillars and a cultural that it feels like I won't say a failure, but it feels like a last and only resort to go to court rather than a first resort.
I think that's why when you say cultural shift, the point is, where does it start from? So I've been talking about it, and I've said it so many times that whoever people must have got tired of my ranting. The word ranting has been used for what I do. But the way I looked at it was, like you were saying, that the justice delayed is justice denied. So all I'm saying is, let the Chief Justice of every country just go out on national media, whatever media, and mass media, and fold their hands and say, look, we are the most inefficient institution in the country. We have not been able to give justice. We've actually denied you justice. Please don't come to us. There is no use. It just doesn't work.
Yep.
Why don't you look at mediation as an option? It seems to be a good option. And like a country like ours, where it's as good as a court decree. Look, you get a court decree sitting in your village in India or any other country. I mean, for whatever, please go there. Coming here, it hasn't worked for you, and we of course are overloaded and we can't do our job properly. And if any other arm, say in the government, if they had done this and sitting on matters for 20 years, we would have pulled them up, but no one can pull us up because we are the colonizers institution. So please don't come to us. Then I would say, yes, a cultural shift can happen, because if the Chief Justice of a country is saying, look, we are inefficient, we don't deliver justice, and you have an option, not pushing people there, telling them about the option, but also that settlement agreement, the enforceability should be very clear, and don't leave any don't give any loopholes to lawyers to get out of a settlement agreement on a general level. So don't do that. Give them a law which protects that aspect. Look, I mean, imagine, like I said, one law which for us is for the entire country. Confidentiality protected, without prejudice protected, with the mediator not being called as a witness protected, all that in one law for the entire country. The US still doesn't have that. I mean, imagine that today outside the court system, where is the confidentiality protected in states? All those things are not done. So I'm saying that these are things that people don't pick up and maybe discuss, because they just take it from whatever they see on the face of it. So I'm saying that is cultural shift. Maybe start from there, because if the colonizers institution, the head of that institution is saying, please don't come to us, maybe people would think twice. Because finally, according to me, I'm not saying mediation. I mean, if you can just negotiate within yourselves, whatever you want to do, mediation is an option. And if either people have not found value in mediation, so let's dig a little deeper into that. Because if all these years, if they're not using mediators first, maybe they haven't found value in it, or they haven't seen the right side of mediation. Maybe, like you said, settlement conferences is what they said, and they don't want outside the court system to go to a person who will tell them what to do. So maybe that is that. So I think digging deeper into each of these aspects is important, because again, like I said, in a lot of countries, mediation hasn't really developed so much. So at least let's start them off properly. Let's not make the same mistake and after 40 years say, look, we should not have gone this route. I'll tell you the Indian example. I had asked Mr. Panchu, who's the one who started the first mediation center in the courts, to come in, because when they started that, the same thing, that basically the mediators get kind of nothing. We had this discussion in the sessions of the conference, that a litigative lawyer on the top level, I mean, I'm saying the one of the top guys, gets about $30,000-$40,000 a hearing. And this person who was there in that session is a mediator in the court system. He said, I can go through hours of sessions. I will get $100.
Oh my.
Through the entire process. So now how do I tell a young person who is just graduating from law school that, look at this route, it's damn good, you will get $100 for hours of work. Don't look at litigation. What do you get? Look at your lawyer. He gets what, $30,000 of hearing. That's nothing. Come to $100. So we are living in a materialistic society. How do I tell a law graduate to rise above all that? there are
Right.
basic needs. Maslow's need hierarchy theory is there. We can't, we don't fight all these things. So I'm just saying a lot of these things, of course, mediation doesn't develop. We say that yes, people say, look, the courts have been able to at least put people into mediation. Is, first of all, is that mediation? And what use has it been? Putting them through a process which finally, if they don't even want to do, and they don't want to take it forward in their lives otherwise. So I think we need to have a broader discussion on these things, and I'm looking at you to give us, show some light.
Well, let me go back to something that you said, that the best approach would be for the Chief Justice of whatever state, court, country to say, we are not doing justice for you. You need to figure out an alternative process. I think that we have seen some of that bubbling up naturally in different jurisdictions. I think California and the federal court system is a great example of that, where people's disputes on civil cases are delayed years, I mean, decades, before they can get a trial. And so I think we've seen people recognize that the court is delaying justice because it's denying justice because it's delaying it for so long, as you say. So I think that the better approach would be what you're suggesting, that there be a direction from above, saying, look, we can't handle everything. Go, use other alternative methods for resolving your disputes other than going to court. But I think we are seeing some of that bubbling up in the community. And particularly, I think we've seen it around COVID, when so many trials got delayed, so many hearings got delayed, so many judges were backlogged and were scrambling to try and get things done, particularly at the beginning. So I think that cultural shift, I'm hopeful, is happening on some level, not as quickly as one might hope, but I do think that cultural shift is happening on some level. And I think you're right. I mean, we have the system that we have, and the question is, how can we make it better and value the alternatives to litigation, in the same way that we value that high level litigation attorney, in terms of dollar value.
Right, because then finally, look, in a materialistic world, the value that you put to people and a process,
Yep.
of course, the amount involved comes into the picture. And I give this example. I just sometimes feel I'm just repeating myself too much, because I do this in various sessions. But there's this very senior mediator in Nigeria. So in one of those sessions, not in the conference, otherwise, he was talking about his experience. He also goes to those mediation centers in the court annex mediation center. So he said, I walk in there. Now I'm going in as a mediator. I'm not wearing my robe and the wig. So I'm first of all treated differently. That's one on that's where, because the lawyer comes in with all that. Then I'm getting that very piddly amount. They get only $40 for the entire mediation. So now the parties gauge me because of that. That one person said, okay, this guy gets paid as much as a clerk. So I mean, that's the kind of view that you have of the mediator. Then what is the respect for the process if there's no respect for the mediator? So those things, because we put into place, the courts, for them, like I said, for me, focus is also the mediator. It's not about promoting mediation. I mean, what is the use of promoting mediation if it is not going to be valued? And the mediator is not going to be valued. So I am saying that this service that is being done to both, actually to both. The word, yes, that word is going around, that there is a concept of mediation and it is connected to the court. Something happens there. We don't know what, some of them don't even know. And they first of all connected with arbitration also. You talk about mediation, they say arbitration. So that's another connection we have to disassociate people from. That also is becoming a problem. We have institutions which are mediation and arbitration institutions. Keep it, they're two different processes. Why don't you just don't confuse the user? Because within the world, there's no confusion. Then you know what the process is. But
Mhm.
we are not the ones, the users. The user is the one we have to have
Right.
using the process. And once that connection happens and the word goes around and both the aspects are connected. So I think first of all,
Mhm.
look, education doesn't work so much on these things, because only a person who's in a dispute, who's looking out for all this, is going to reach that person. On a
Mhm.
mass level, like I said, if the chief justice is going out and putting out the facts, it's just the facts. Just I mean, all I'm saying is step down from the pedestal. I don't know about the US. How high is your pedestal? Here, some of our courts, those pedestals are really high, because the colonizers person had to sit there
Yeah.
because that's
Right.
the way it was done. I don't know how have you changed your structure or not. No, our high courts and the Supreme Court are still structured in the same way.
Mhm.
So the whole attitude towards the people also is the same, and I think
Right.
that's happened a lot of places. So stepping down from the pedestal, Julie, is that possible for the Chief Justice or for the judges in general? Is that going to happen? And talking about this to people on a one-to-one basis, kind of thing.
Is that going to happen where there's an announcement from above that we can't handle it? Doubtful.
Give us some
Doubtful.
hope, Julie. Give us some hope. I
I
said,
think
show us the light. Show us the light.
I will show you the light. So I think let me just look at the U.S. system for a moment, because every jurisdiction in the U.S. has its own chief judge, chief justice, chief, judicial officer, whoever that is, and that can be even as on a county level or a city level. And so it could happen and should happen within those parameters, within those spheres. It's never going to happen, I don't think, in the US system as a whole. I don't think that John Roberts is going to stand up and say, listen, we can't handle you guys. We can't handle your cases. So go figure something else out. That's not going to happen. But I think it can happen in the jurisdiction in Minnesota where Sherry is. It can happen in the jurisdiction in Colorado where I am. It can happen on a statewide level. But I don't think it's going to happen on a national level. So I think that incremental change, it wouldn't be incremental in the jurisdiction. It would be huge in the jurisdiction, but it's not going to be that. And it could sweep other places, but it is not going to be as you've described it, and what might occur in India or another country where the Chief Justice of the Supreme Court, makes an announcement from above. But I do think it can happen. So there's your hope.
Okay, so let's start from the ground up. Let's start from these the whatever the district courts or whatever the courts are called in each country. Let's start from there. Let's go request these whoever the heads that judiciary in that particular region. Let's start from that. So Sherry's going to do that. She's going to tell us what feedback she got. So let's maybe do that. But actually, look, you have to look at it from what again. This actually it's the colonization discussion. But the fact is that the colonizer created laws where you could put someone behind bars. The trial is happening, of course, but we can put you behind bars. You take someone's freedom away. We don't know what the outcome of that is. I mean, one day of taking away someone's freedom, and after in India, there's cases where 20 years later the person is acquitted. You have, and the person has been behind bars because the colonizers, whatever
in the US
institution.
as well.
Yeah. I mean, should you be able to do that? I mean, those are questions that you have to ask yourself, that are we going to continue this? Are we not going to change what the colonizer gave us in terms of laws? Who are we to take away someone's freedom when we cannot give them justice the same day? Same day. Why should the person even overnight be in a cell? I mean, come off it. These are human beings whom you do not know what the outcome of that case is going to be. And even if the outcome goes against that person, whether that structure of that cell and the jail and all that which the colonizer has given us, whether that should also continue, that's another discussion. I mean, that's of course it needs to be discussed. Just the fact that up till that point is reached, you have taken away that freedom because someone
Right.
sitting on the thing said this, that yes, this person should be behind bars because prima facie case goes against it. But that prima facie did not work because the person got acquitted. That means you went wrong. So leaving someone to gauge that. I mean, why I'm saying this is because our courts obviously are not being able to deliver justice. So now you're
Yep.
putting someone behind bars. On the other end, you are talking about mediation to people. You are sitting there to decide which matters go to mediation. You take, you can understand how our courts function. I mean, you have, say, 50 matters of listed, 60 matters listed before a judge. How much time does he get? I mean, minutes. And in those minutes, you
Depending, yeah.
in those minutes you had, on one end you have someone who's lying in jail, is bail application. On the other end you have a divorce case, and you are discussing with the parties whether they should go for mediation or not in those few minutes. I mean, we have to be able to look at both those aspects,
Right.
of whether, if the judiciary cannot do its work, just move out of it. Don't have spend half a second also on talking about a process to someone, which actually on the other end, balancing it out on your time, is of per person's life and liberty. So
Sure.
I think that's why mediation in the court system also, in this sense also, court, even coming to a court and having to talk about mediation before a judge who has so much more to do, I think that also is, for me, is a problem. I don't know how you look at it.
That's no, I mean, you're right. Judges have very limited time, and the priority by law is and should be the people whose freedom is at risk. But I always said that we, as judges, decided the 3 F's in people's lives: freedom, family, and finances. And all of those things are critical. All of those things are important. But in the US, and I hope in most countries in the world, the freedom is the one that takes priority. So if I have 2 trials set the same day, one is a divorce trial dealing with the very important issues of family and finance, and the other is a criminal trial, that divorce trial is not going to happen. And so people, if they want to come to court for resolution in that case, or in a civil case dealing with finance only, they are going to be pushed to the back of the line. And so I think that that way that we prioritize cases is correct, but it also creates those conflicts with folks needing to find, wanting to find, benefiting from finding some other resolution process.
Yeah, because like I said, finally these the discussions are going to be connected, because again, whether the court should be involved in certain things or not being involved in certain things, that, and then whether, of course, on one end is the freedom of a person who is in a jail, and one is freedom of a person who's in a relationship. Are you going to balance it out, that minute of their life here? And because we have created a certain framework of law that up till we don't tell you, you can't get out of this. So we keep you trapped in this, there we keep you trapped in another cell. So I mean, there's lots of things. So finally it all comes down to the state wanting to get involved in your life. That's what it comes down to.
Bottom
and
line,
how much of that involvement is required. So that's the decolonization discussion for sure. But from the court system, in terms of the mediation part of it, anything, I've given you the broad points that I have thought of, but of course with your in-depth experience and being an insider, from that perspective, I just felt that maybe you could, like I said, show us the light into how things should be maybe done differently, thinking that the law will, if the law is required to be changed, it can be changed. Don't be confined by the law. Right? We are discussing it. We're not confined by the law. We create the law. Because we're living in a bubble. We have this Zoom meeting. We can say anything we like. We are not confined by anything. So not being confined by the law, but looking at the practical situation, how would you structure, again, same question, how would you structure mediation? And in that sense, would courts be an option, not be an option, or what other things would you think of? How would you do?
Yeah, I mean, just brainstorming a little bit, maybe courts deal with criminal matters and other disputes, family, civil, those other issues are dealt with through the mediation or alternative process. So that could be I wouldn't say it's an easy fix, but it's certainly a way to decouple the court from those matters that can be resolved in alternative ways.
Yeah, because when we talk about arbitration, the fact is that you choose your judge, you decide the process, you create your own court. I mean, why
Correct.
does the state have to get into your commercial dispute?
Right.
I mean, you
Right.
don't need to. You do that. And if supposing you can't afford, now the pro bono part of it comes in. Free and the pro bono. That's why that's another discussion we're having.
Yep.
But that is where
Right.
that discussion comes in. I mean, you can afford
Right.
it. You can you can appoint your own judge. You can pay for the judge. I mean, of course,
Yeah.
arbitrator, and you can create the infrastructure for yourself, or you can use some infrastructure. Why should the state be involved in? I really don't understand. If you can tell me.
Right. Well, and the state, and the state is we the people fund dispute resolution,
Exactly.
whether it's happening in a court or in a different process that is outside of court that eventually leads to court.
Because that's what I'm saying. The funding people's disputes, I think that cannot be the priority of of government, because there's so much more to do. So how much can we take out from there? But of course, that's another discussion. But from the mediation perspective, I mean, I was wanting you to, of course, give us, say, steps that you feel that should be taken. And of course, I mean, whether it's worked or not, I've given my view based on whatever I've picked up information. How you are looking at it working, you can tell us. Has it worked? First of all, first question is, has it worked? Has it mediation in the court system worked?
Yes and no. I think it has worked to give alternatives to people. I think that it has worked to introduce people to a different process and a different way of thinking, especially when it's done well. I think that it has served the court in terms of resolving some disputes that may not have been resolved otherwise. But I do think that it has become a bit of a forced process by the court, and by being a forced process, it isn't really as beneficial as it could be in terms of being pure mediation. I think it also challenges some of the confidentiality pieces, because courts expect a result and a report on what happened in mediation, and that is contrary to the confidentiality requirements that most benefit a true mediation process. So I think that it compromises mediation, but it also has benefits to the participants and to the court. So it is a boon and a bane, to go back to our title.
Now also, at the same time, you have to tell us, for the mediator, is the boon or bane for the mediator? For mediation, yes, you've given us the larger thing of mediation, but for the mediator, boon or bane?
Again, both. I think that people, at least around here, often shop for the least expensive alternative for mediation, because they're required to do mediation. So they go to the court mediator, they go to the free mediation. They aren't willing to pay for mediation, and what they end up with through that process is more of a settlement conference or conciliation. They're not getting true mediation. So the mediators, I think, are not, looking at it from their perspective, they're not getting paid what they're worth. They're not as satisfied with the work that they went into, because they wanted, if they were truly doing mediation and wanted to do mediation, they're not doing it. They're doing, shuttle settlement conferences going back and forth. And so I think that they're getting business, and they may get increased business than they would otherwise if there weren't a court requirement. But I think that they are not seeing the results that they envisioned when they learned about the mediation process and hoped to make a career as a mediator.
Perfect. And I'm not going to keep you in the box for longer. So, but you have to be part of the colonization, mandatory mediation, all those discussions. Look, it's just putting thoughts out. There's no
Yeah, no,
conclusion as such. I mean, we just and
very, no, very interesting, good discussion. I really am grateful for the opportunity.
Oh, thank you very much, Julie. It was wonderful talking to you. And I'm telling you, we need those other sessions to discuss that. So please be part of that. So thank you very much.
All
And let
right,
me
thank
just